Welcome to Fundamentals for Startups. My name is Sally Ann Price. I'm the writer on our marketing and communications team here at CoMotion, and I will be your host today. If you've joined us before, you know that CoMotion Labs is a multi-industry incubator hosting early-stage startups from within and outside the UW community. We are committed to nurturing and enabling the success of our startups, providing critical infrastructure, and offering opportunities for learning, mentoring, and networking. And we do all of this without taking equity or IP. We have 3 incubators on campus, life sciences and hardware at Fluke Hall, and tech here at Startup Hall. If you are a founder looking for a community to help your startup grow and flourish, we would love to talk to you. Fundamentals for Startups is a regular lecture series open to anyone interested in learning about entrepreneurship or building a startup. Every week, we bring in experts with diverse perspectives and experiences to share insights, inspire action, and offer space for questions. A few announcements before we get started. All of the Fundamentals for Startups presentations are archived on YouTube and on the CoMotion website, where you can filter by topic. To learn about and register for future events, visit CoMotion Labs online and subscribe to our YouTube channel. I will also add that this event today is part of UW's first ever Innovation Month. This is a campus-wide celebration of the innovation that happens everywhere at UW. It encompasses 65 plus events hosted by dozens of academic departments from STEM fields to the arts and beyond. Visit uw.edu/innovation to check out the full schedule. And out here in the lobby, we have some buttons and other swag. Today, I'm excited to introduce Katrina Breedy, Copyright and Trademark Manager here at CoMotion. Katrina is a licensed attorney who will share insights into the trademark process for startups and how it can help you grow. The talk will also include a frank discussion of a DIY approach to IP protection rather than hiring an attorney, and both horror and success stories from the field. Welcome, Katrina.
Thank you. I'm going to give your notes back. Don't confuse myself. Thanks, guys, for having me here. It's really great to be in a room of people that are either in startups or thinking about startups or just have kind of a little bit of an entrepreneurial mindset, because truly trademarks is something that I came to late in my life, certainly because I went to law school late in my life. But once I discovered it and realized the doors that it opened in terms of sort of understanding the economy and understanding how just how companies find their place in the marketplace, it's been truly illuminating to me, and it's become one of my favorite subjects. And so hopefully some of that enthusiasm for trademarks will rub off on you guys today. And I just wanted to say, like, I do have time at the end for a Q&A, but if there's anything that you see or you hear that you would like just to expand on a little bit more during the talk, feel free to ask questions. If there's a lively discussion, all the better, because this is a topic that deserves it in my mind. So we'll talk a little bit about trademarks for your startups and protecting your brand identity. First of all, we kind of have to know what a trademark is when we discuss this topic. Trademark is a term that gets kind of slung around pretty casually sometimes, even in a very informal way. If you've come up with a clever phrase, it'll be like, well, I'm going to trademark that, or that's my trademark. But what does that really mean? So when we're talking about trademarks, we're talking about, specifically a word, a phrase, a symbol, a design. And when I say design, think logo, or a combination of all of these things that identifies or distinguishes the source of goods from one party to those of others. And a lesser known term is more of a service mark, and this is meant to communicate the same idea, but it's to designate a service and the source of a service in the marketplace. Either they're a little bit interchangeable. If you have a service, you can still use the trademark identity and speak of it that way, and people will understand. So we'll look at some sort of famous trademarks. When you see these, you kind of have an instant opinion of what this means and what this product or service is, and maybe the value of that product or service in the marketplace, good or bad. They would hope that it's good, but you never know. There are two basic requirements for a mark to be eligible for trademark protection. It must be used in commerce, meaning it must be transactable. People must be able to find it, use it, buy it, whatever, and it must be distinctive. So if you are thinking about starting a small coffee company and you would like to call it Farbucks, you are not going to get trademark protection because you are not distinctive. There is a difference between a word mark and a design mark. And so on the left, you can see Just Do It has become a word mark for Nike, whereas their swoosh has become a recognizable design, and that is also equally protected by trademark. Unaware if you know that even sound can be protected by trademark. I'll give you a couple examples of some famous sounds that you might not have realized, like, oh, wow, that's got trademark protection. But first one. So both of those, hopefully you recognize them immediately and distinctively, and you understand exactly what those sounds mean. Also, there are circumstances where colors can be protected by trademark. This is a little bit more rare, and this comes from basically a 1995 Supreme Court ruling where they held that there was nothing in the enabling legislation, which is called the Lanham Act, and we'll talk about that a little bit later. But there's nothing that prevents color from being served or from serving as a trademark. There's just some criteria. The color needs to distinguish the product from the competitors. It has to be associated with the product through commercial use, like it's acquired its own sort of meaning. It can't affect the product cost or quality, meaning it can't put other competitors at a disadvantage because of the use of this color of the mark. And it must not be functional or have a utilitarian advantage. And we'll discuss that a little bit in the next slide. But I'm wondering is there anybody in the room that can immediately identify all of these colors? Or do you have a sense of what these brands are? Or do you have any kind of a feeling about these colors when you see them on the screen? And I'll take, if anybody wants to just guess, I will take that. Okay, in the back.
The orange on the bottom is Siemens. Oh, sorry. The orange on the bottom is Siemens. Siemens Healthineers. I worked there.
Is that Tiffany blue on the upper left and then Phantom black on the far right?
Okay. And I will also maybe give the caveat that sometimes colors on a screen don't necessarily represent super well. So we're definitely got some, yep.
UPS brown in the upper right.
Okay. Any other guesses? Got one over there.
Perhaps Louboutin red in the middle.
Sorry, what was that?
Louboutin, the like shoe brand with the red sole.
Okay. All right, well, I'm going to, and you can, so we had two good guesses there, I think. I'm still not sure the one that you said, I don't even recognize that.
Siemens Healthineers and Siemens AG.
Okay,
The medical device.
gotcha. No. Like I said, there are very few companies that meet the criteria for having color as a trademark protection. You might think of some other famous colors and wonder, like, why don't they have that? And an example of this is Pepto-Bismol. They did not get the pink protected because there had been studies of patients that found that they're more likely to actually take the medicine because of the color, and therefore the pink was more functional. And so that doesn't give it its protection. And similarly, General Mills, maker of cereal, couldn't get the yellow of its cereal boxes protected because other boxes used similar colors, and so it wasn't distinctive. So those are the two kind of eliminating factors there. This doesn't really come up a lot in trademark law, to be honest. I just find it a pretty interesting diversion to see what people can recognize and what they can't out of colors. When we're thinking about trademarks and trademark protection, oh yeah, go ahead.
Quick question on color. One question on color is, and you might address this later, but with logos, the logo showing up in different colors, is that important?
Yes, it actually is. And having color in your logo is different than a color, like the Tiffany blue, right? And so often when you, and actually I don't know that my presentation goes deep into this, so it actually is a very good question, but when you have protection for a design mark, oftentimes you will indicate color is a feature of this mark, meaning the Starbucks logo is going to have to present in a particular way with particular colors of green. They're not going to protect every color of the rainbow associated with that same design. So color is in fact quite important when it comes to design. Oftentimes brands will have both a design mark that has those colorful features in them, and then they might also have a black and white protection for what's called like a knockout of their logo. When we think about trademark, we always think about them on what's called a spectrum of distinctiveness. And remember, being distinctive as a mark is what gets you the most trademark protection. So when I advise clients, I want them to stay to the right end side of this spectrum because that gives you the most and the broadest protection. On the left-hand side, words that are kind of too generic or it's too generic of a description of the product will never get trademark protection. So you cannot come up with a beer and call it beer. Like, it won't work. Similarly, words that are descriptive, if they're too descriptive, you're also not going to get trademark protection. If you have named your new company Northwest Pilates, no. You can still use Northwest Pilates, of course, in commerce. You're just not going to have the protection that a trademark offers you. As you move kind of along, you'll see kind of examples of, once you kind of hit the suggestive, the arbitrary, and the fanciful, that's when your protection becomes a lot more likely from the U.S. Patent and Trademark Office. And when I say this protection, I just mean that the U.S. Patent and Trademark Office has registered your mark and has sort of authorized that protection. Like I said, there's nothing to stop you from, creating a beer and naming it beer, but anybody else can do that too. So you're not going to have a good time distinguishing yourself in the marketplace. Honestly, I think the best company names are the ones that are fanciful. They're fanciful because they didn't exist before. It's usually an amalgamation of names, concepts, putting people's initials together, whatever, and you come up with names like Kodak and names like Pepsi that become, through their quality and time in the marketplace, have become very recognizable. And they almost seem like, well, I've known them forever, but when they started, they were just made up words.
So, curiosity, so you mentioned suggestive, it hints at the attribute of the product or service.
Yeah.
So that would almost seem like it's not a good thing?
No, it actually is. It is kind of a good thing, right? So if we use like Netflix as an example of this, you hear that name and now, of course, we're like, oh yeah, it has something to do with movies and maybe there's the internet involved. We're using the word flick from movies and we're using the internet. But that's not, otherwise it doesn't really mean anything. I'm only kind of suggesting that we're a company that streams movies online. Or at the time that this was first came into being, it was a company that sent you movies via the mail that you ordered online. So suggestive is quite good. Those names are always pretty powerful. If you can just sort of say like, yeah, Microsoft, we're small software or whatever. The arbitrary ones are the ones where it gets sort of interesting. A company like Apple, obviously if they were a food company, that trademark would not work at all. As a computer company, it works quite differently. And I actually have interesting things to say about Apple later, because I sometimes wonder why they do what they do. So let's move on a little bit. I mentioned this before. And just as a general sort of like legal primer, all the protections from trademark in the United States are enabled from the Lanham Act that came into being in 1946. And it's not that we didn't have trademark protection before this. This just really codified things and modernized it. And it's the system that we've been working with since this time. So what trademark protection allows you to do, or what the Lanham Act enables, is a nationwide system of trademark registration. The owner of a federally registered mark against similar marks is protected, and it protects the owner of a federally registered mark against dilution of a famous mark. So sometimes if you, for example, if you think about the company John Deere and their tractors and their very strong mark, you couldn't have another company called John Peer that was doing something less than nice with with machinery. It happens. I mean, those are kind of the lawsuits that are filed a lot. Like, you're doing something with our brand it's tarnishing our brand, or it's making our brand less powerful. So we'll get kind of around to what you guys are dealing with here as entrepreneurs and small business owners and people just getting your companies off the ground. We'll talk a little bit about why trademarks are important to your startups. First of all, they create immediate value. They automatically give you a name and hopefully a strong name in the marketplace, and hopefully something that's really evocative of what you're doing and your services and what you want your potential growth to be. If I see one thing that has happened in startups a lot, I feel like I see a lot of times that people don't put enough thought into, like, what is our company going to be, or what are we going to be in 5 years from now? Really putting a lot of effort into that is what kind of lands you with the best and the strongest name. And it's an asset that grows in value along with the business. The more the business grows, the more the brand goes along with the value. And the goodwill associated with that brand just becomes exponentially more valuable. Oftentimes, when there's a purchase and sale of a company from one to the other, or a merger, there's sort of a line item that's accounted for in those purchase and sale documents, and it's just for goodwill. It's hard to attribute, like, what is that value of goodwill? Like, we know what our inventory is, we know what our assets are, we know what potentially the next 5 years of growth looks like, but what is that goodwill? It's intangible, but it is valuable. Secondly, trademarks give business a geographic advantage. And this is true even if you have not registered your mark. Even if you're just sort of using sort of common law, you still would have a local predominance of using that name in commerce, provided you were using it first and it was otherwise worthy of being protected. Trademarks can prevent financial waste. And by this I mean, trademarks help businesses get ahead of problems. So if you register early or you start that searching early, you can spot potential competitors that could make expensive demands of you later. There's nothing worse than getting pretty far down the road with your company and you realize, like, oh, there is a problem with a pre-existing company out there. Now I have to change my logo, I have to change my name, I have to change my website. All of those things are very expensive propositions, when what you really want to do probably at that point in your company life is be getting your product out in the market and connecting with your customers. And lastly, trademarks last forever. So as long as the mark is being used in commerce, it is valid and it is enforceable. So I'm going to throw a trivia question out to you guys here. What do you think the oldest existing trademark is in the US? Nope. Nope. Sorry?
The flag? The United States flag?
Nope.
Just a guess, United States Postal Service?
Nope. You're getting closer. You're getting closer. You're getting closer. It's not really anything government related. It's a private company.
Is it a tobacco product?
It is. It may be a hemp product. There might be some hemp involved. I'm going to give you a hint. Okay, I'm just going to give you a hint. It's not the name on it, but it's going to tell you that it was registered in the year 1884.
Railroad?
What do you think?
Railroad.
Oh, railroad. No. It is, in fact, a company called Samson, which is rope. Yeah. Yeah, it's a rope company, and it still exists. That you can check out the website. And not only are they still selling rope, I think they've expanded into marine technology. But yeah, at the basis of it, Samson rope. So used in 1884 and used in 2024. So there could be some questions here. Why should you register your mark? I gave a little bit of illusion there. You do have some common law rights, even if you don't register your mark, but what are maybe the reasons to register your mark? First of all, by being listed in the USPTO database, it effectively provides a public notice that I'm using this mark, this is my company, this is how I'm using it, this is me. And because you're doing that, because of the registration, you have therefore created a legal presumption of the mark ownership. And that's going to give you a lot of a stronger foothold. Thirdly, and maybe I don't want to say it's most important, but it's an important consideration, particularly if you're a company that thinks that you're going to work internationally. It gives you a basis for filing trademark protection in other countries. So it provides your United States foothold, and it allows you to kind of leap from there. Fourth, it's really cool to use that circle R on your products. It tells people that you have gone through the effort to protect this. It tells people that you think that this is valuable. As a shorthand, I would say that even if your mark is not registered, or if it's not registered yet, use the TM. You can use that, and that also puts people on notice. So the TM is used for marks that you consider protected of trademark, but you have not registered, and the R is for marks that have been registered with the United States Patent and Trademark Office. And lastly, this is actually kind of interesting. I didn't really know this until fairly recently. But if you can sort of have your product and your trademark listed with the U.S. Customs and Border Patrol. And so if they see infringing marks coming in, they can stop it there. But will they? I don't know. Yeah, I've never really seen that in action, but it is a thing. So we can talk a little bit about the trademark registration process. It's not wildly complicated. Oh, question, yeah.
Sorry, that's a quick question. So this
You have a microphone coming to you.
Yeah. So the protection is only when it's in the same field, am I right?
Yeah.
So can I have, let's say that I have a diagnostic kit and then call it Apple with the same logo of the Apple and the same color and everything?
And it's only a medical diagnostic kit?
Yes.
You probably could. That doesn't mean you won't get harassed, right?
Yeah, yeah. Okay, I see.
Yeah.
But yeah, as long as the field is different, you can do that.
Yeah.
Okay, thanks.
But also it kind of depends, and I will go forward to say, I don't know, I don't think Apple is going to expand into that territory,
Yeah.
but if they do, they might have some, predominant use of the mark. So
even though that I started first, the diagnostic kit, they came after me, still they could come and sue.
potentially, because there's nothing going to stop. I mean, some of the questions about trademark are really about business and how do you want to spend your time. And even if a lawsuit from Apple was fruitless, why would you want to invite that? Because they've got a lot of attorneys. Yeah.
Because I can use the Apple because I can create that illusion to the customer that this product is kind of is sponsored by Apple, is being supported by
Yeah,
Apple.
I mean, you could be creating false connections.
Yes.
And Apple would certainly come down on you in that. Even if they looked at, they're like, oh yeah, this guy's clearly in class 10 and that's not us. It doesn't matter. They're still going to probably, take some action against you. We're like, yeah, you're either diluting our brand or you're tarnishing our brand or you're trying to piggyback off of our brand. So if you came into me as an attorney and said, I have a diagnostic kit and I'd like to call it Apple, I would say, don't do that.
Yeah. Okay, thanks.
Yeah. So the trademark registration process is a fairly simple thing to go through. It's an online tool. It's an online portal at the United States Patent and Trademark Office, or just USPTO for short. You know, and you kind of go through a 6-step criteria here. First of all, you decide if registration makes sense for your business. Maybe it does, maybe it doesn't. If you are somebody that is maybe you have a local bar or hair salon or something like that, which is likely to not have a large geographic spread, you might think, I don't really need this. I have some common law that I can fall back on if anything happens, and I can still use my mark as long as I'm not infringing. You might think that that's the answer. But if you have any aspirations of growing and scaling your business, and certainly doing anything interstate, intercommerce, then you're going to want to think about federal trademark protection. Assuming that the name of your company sort of meets that spectrum of distinctiveness, and you think that you would get that protection. Secondly, you're going to kind of select it. Do I want a word mark? Do I want a design mark? Do I want both? Sometimes they both make sense. You need to identify the goods or service that your mark correlates with. And I'm going to talk about this a little bit on the next couple of slides. And that's kind of a little bit of what your question was getting at. You want to make sure that you do a good, thorough search, the USPTO database. It has actually gotten a lot friendlier in the last 6 months or so. Prior to the last 6 months, when they did a rehaul and a refresh of how their search engine works, it was like working with a GeoCities page from the 1990s. It was just really antiquated and a bit of a challenge to kind of narrow down. I love what they've done. They've made it really user-friendly. You'll need to determine your filing basis. And I'll talk a little bit about this later, but filing basis sort of implies, are you using it now in commerce, or do you have an intent to use it maybe a year from now? And we'll talk about the strategies of that in a couple slides later. Lastly, you just kind of prepare your application, you create specimens, and you pay your fee. Oh, sorry, we have a question back here.
Yeah, I have a question about, is it just like patents where when you file, you have to decide which region you want to file it for? Or is it just applied globally every time you just file for a trademark, it's just global? I mean, how does this work?
It's not like patents in quite that way, and I will admit to saying that I'm not an expert on patent filing, other than my understanding is that when you file a patent, you're generally filing it in the US.
Actually, no, you file it in the US, and then you have the option to file it internationally in a different region. Like Europe is one region, Japan is another region, and so on. So I'm just curious about trademark. Like if I have a trademark that's registered in the US, does it apply globally?
It doesn't exactly, and that's definitely a topic that I'm going to hit on a little bit later in the slides. When you file a trademark in the United States, it is just good for the United States. It is not even North America. It's really just the United States. But it does give you that foothold. If you decide that you are going to file globally, there are steps to take to do that. But effectively, it's like it's a country by country filing. There are ways that make it a little bit easier, which I'll mention a little bit later. But no, you're not filing for global protection, and there's no easy like tick this box and I have global protection. It really varies. And the costs vary per country. So, in the US, if you were filing a trademark protection, this is very much unlike a patent. Patents are actually pretty expensive to file. And one thing that you want to think about a patent is like, am I going to be in the position to even make the cost of this expense work? Or am I just do I have the ability to license out, or is somebody going to buy it off of me? Trademark is a little bit user-friendly on that respect. You do file a fee based on per international class that your product goes into. And that is, there's a kind of depending on kind of what level of service you want, but we'll just say that the mean price is about $275 per class. So let's say you're just filing one word mark and one class, that's $275. If you're filing a word mark and a design mark, then that's in one class, then that's two different filings, so $275, $275. If you're filing a word mark in 5 different classes, then that's 5 times 275. Hopefully that kind of math works out for you. So this goes to your question earlier. When you're looking for the international class that your product goes into, there are 45 different international classes that Trademark considers. The first 1 through 34 are goods, so you've got some sort of a widget or a device. And then classes 35 through 45 are for services, like lawyers or doctors or education services. I put a little bit of a asterisk across some of the marks that certainly here at CoMotion that I work with most frequently. Obviously, we have a lot of pharmaceutical products here. We've got computer and software, which is class 9. Class 10 is medical instrument products. But the idea is that your good is sort of determined by what kind of product you have, maybe what materials it's made of. Leather goods could be anything from a wallet to a purse to chaps. I don't know. We got a question here.
What happens if you have a good that maybe falls into one or more class, like 9 and 16?
Sure. Yeah, it happens all the time. So you might have some decisions to make, like, are you going to consistently be using those 2 classes for the lifetime of your product? Then you should register in both classes. If it's really aspirational, though, and you're just trying to get some scattershot protection, and you're saying, like, well, I'm going to be in 5 or 6 classes, well, you're paying per class for one thing. But then secondly, you need to have something in the market for all of those things, and you would have to demonstrate that you have something in the market for that. You also run the risk of getting audited by the USPTO at some point. Sometimes they'll pop in, inter-registration years to determine, like, well, I don't see this on your site. Are you still using this? And you kind of have to go through and prove that. So my guidance as an attorney is generally to really just cover what you're actually using or what you are really plausibly going to use. It's not a great strategy to try to strangle out the rest of the market from using this, particularly if it's a good that's really not related to what you're doing. This is sort of the rest of the goods. Clothing, class 25, is a pretty popular category here. And then these are what the services look like. Again, I put an asterisk next to the ones that I hit most often at CoMotion. Education and entertainment are, oddly enough, in the same sort of category. So I hit entertainment more as a private practice attorney, but CoMotion education is obviously the hugest thing here. Obviously, computer and software services are huge, and medical and agricultural services are large here and popular here. I mentioned this a little bit earlier. This is the filing basis that you kind of needed to determine. And what I had said earlier was, like, are you actually using it? And that's sort of like the term, like, actual use in commerce versus I have an intent to use this. The reason that there might be a distinction on this, like, perhaps you come to me as an attorney and you're like, well, we're just doing business development on our company, or we haven't quite launched yet, but we're definitely going to launch within the next year. Then it might make sense to go ahead and file that trademark as an intent to use. And you kind of get that preliminary approval from the USPTO while you're waiting for all of your other business development things to sort of lock into place. Another reason why it might be good to do this, if that is your timeline, kind of a 12-month timeline, is that the registration process at the USPTO kind of takes a while now. So if I submitted an application for any of you today, it's going to be about 10 months before an examiner even looks at it. So if you've got something sort of in that 12 to 16 month horizon, go ahead and do an intent to use application. And then when your product actually becomes available in the marketplace, you can convert that application to an actual use. And there's some fees involved, but it's pretty minimal, and it could be worth it just to have that jump start on your business.
Is there such a thing as a trademark pending, like there's patent pending?
It doesn't quite work like that. And I think the reason is that patents pend for a substantially longer period of time than trademarks do. And
so you cannot use that little.
You wouldn't use
TM
the
logo.
term you wouldn't use the word trademark pending. You would just be using the TM, really.
So you can use the TM as soon as you file?
You can use the TM the moment that you're using something in commerce, you can use the TM. So that's whether you've registered or not. And it's just, the registration timeline is really just waiting for the R to come through. Yeah. So the question is, just kind of backfill on this a little bit, like when is the best time to register a mark? When you're formally incorporating your company, that might be the time to register at least your company name, if that's worthy of trademark protection. If you're at UW and you're maybe going through one of the Innovation Gap Fund or the PEP program and you haven't quite spun out yet, the moment you start thinking about spinning out is the moment you should be thinking about, how am I going to deal with my trademark, or am I going to register that? And also when seeking investment. Investors are a lot more comforted by the fact that you've got a company or a product that is worthy of trademark protection, in addition to whatever patents or copyrights that you might have as well. So a little bit of strategy on your trademark, because as I mentioned, while trademarks are not as expensive and laborious as a patent application, it's still, it could add up. If you have multiple products, it could add up if you want to be in multiple classes or multiple countries. So you kind of want to prioritize the names that most give you value out of the gate and that give you the greatest initial value. Keeping future business goals in mind, I want to remind you that you can't broaden your original application to include additional goods and services. So you kind of either need to know up front, hey, I want to be both t-shirts and posters. Those are two different classes. I'm going to file for those. You need to have a very strong suspicion that you might have additional classes, or you're just going to have to file again later if you decide that my t-shirt and poster business has grown to doing online videos, and if you wanted to protect all of it, then that third product or service is just going to be a new application. You want to identify key markets. So trademark is country specific. Registration in one country does not give you rights in another country. So you want to kind of look ahead to other markets and countries when considering your initial mark. Engage early in the trademark searching process. I kind of hinted upon this earlier, but searching before making those significant investments in your website and your design or your brand is going to save you money down the line. And try to secure other key assets around this mark. And by that I mean domain names, social media handles, whatever. Social media handles and domain names are not necessarily, or domain names are certainly not protected by either trademark or copyright. So, but it is just good for the value of your brand to have them as bundled as tightly as you can. And just kind of to summarize this, like if you kind of fail to be strategic, it means that you could be facing an infringement lawsuit yourself, or you're forced to rebrand just as you're gaining traction, or you're unable to stop infringers, or you could get blocked from key foreign markets. I mentioned this a little bit earlier when talking about the strategy of an intent to use versus an actual use, but this is a sense of what the timeline is for any sort of trademark registration. Like I said, it's going to be 10 months before an examiner looks at it. Maybe there's an office action, which is what we call the communication that comes back from the USPTO. They might want clarifications on something. They might need you to disclaim a few things. They might outright reject you and force you to make an argument on things. Usually that process can take 3 months to 6 months. But let's say that things go smooth sailing, you'll get what's called a notification of publication. That's a 4-week process, and basically it publishes your trademark into, I think they call it the Gazette, the USPTO Gazette, and it allows all competitors to see, like, oh, this has been approved for publication or registration. I might have a claim against this, and this is my time to stop that from going forward. I'm sorry for the now loud thing of me hitting my microphone. So as I mentioned, that publication for opposition lasts 30 days. And then after that is cleared, assuming that there's been no opposition to your mark, it takes the USPTO another 6 weeks or so, and you get a nice certificate in the mail, a certificate of registration, and you can start using that Circle R. There are renewals that come up with your trademark use. So once you have it, doesn't mean that you can ignore it forever. Between the 5th and 6th year of your mark being used in commerce, you have to renew with the USPTO. And then again, between the 9th and 10th years. And after that, after 10 years, they kind of assume that you're flying, and then your renewals are only every 10 years. But, so if you think about it, Samson Rope has been renewing every 10 years since 1884-ish. Just wanted to present with you guys a few case studies on what I think have been pretty, I'll call this the good, the questionably good, and maybe the bad decisions in the various slides that I'm going to share with you here. I consider PayPal to be a good example of a launch of what started small and grew strong very quickly and has a very strong mark according to that, because of that. This is a success story because it succeeds. It's otherwise, these are kind of descriptive terms, PayPal. There's nothing really, ingenious about that. But because they were able to position themselves very early as the peer-to-peer network, they got immediately into a unique selling position, and it allowed, just by allowing individuals to send money to other individuals, without having to use more costly services like Western Union. And so, in coming up with the brand and the mark, generally it's difficult, it can be difficult to trademark single words at this point because so many of them have been sort of snapped up. And so this combination of terms makes an immediately evocative, user-focused, this idea of I'm just paying a friend. It's simple and it's descriptive, but together it's just a strong market position. And by that they were able to achieve the trademark protection. So kind of going back to Apple, does everybody on the screen recognize both apples? Or do you only recognize the one? Is there anybody that does not recognize both apples?
Is it Apple Records?
It is Apple Records, yeah. So this has kind of been an interesting and very tortured trademark dispute that has lasted, or did last, 30 years or so. It's over now and been settled. But basically on the left is Apple Corps. It's the logo for Apple Corps Records, which was founded by the Beatles in 1968. Obviously on the right is the most modern version of Apple Computers, founded by Steve Jobs, 1977. Both of them, because the Apple has nothing to do with either records or computers, would be considered kind of fanciful, arbitrary marks. But because they're both that, it is, like I said, resulted in at least 3 different lawsuits over 30 years. And by the time it's all done, we're talking about hundreds of millions of dollars. So the first one was in 1978 to 1981, where Apple Corps, Beatles, sued Steve Jobs' Apple Computers immediately for trademark infringement. That ended with a settlement, and this idea that Apple Computer would never enter the music business, and Beatles would not enter the computer business. Now, one of those parties held true to what they were doing, but at the time, that initial settlement in 1981 it was found that Apple computers would pay Apple Records $80,000, which I think now would probably be $250,000. So, skip ahead a few years. Circa 1986, Apple Computer started adding soundboards, sound recorders, advanced sound chips to their, to their computer setup, and Apple Corps got excited about that, and AGID sued again for violation of their previous agreement. Like, hey, you said you guys weren't going to go into music, and like you're putting stuff on your computer that makes me think you might be going into music. And so again, another lawsuit that that resulted in a settlement. And basically, I want to get the words right here, so I'm kind of scrolling here. That Apple Corps held the right to use Apple on any creative works whose principal content is music, while Apple Computer held the right to use Apple on goods or services used to reproduce, run, play, or otherwise deliver such content, but not on content distributed on physical media. In other words, Apple Computer agreed that it would not package, sell, or distribute physical musical materials. Now, that was all done prior to iTunes, obviously, and between 2003 and 2006, Apple Corps is like, wait a minute, you guys are now in music, and you're using this logo to sell music, through your iTunes Apple Store. In this case, Apple Computer probably was in the guidelines of what they'd agreed to on the previous settlement, because they weren't selling physical media, they were selling digital media. They probably were going to be okay, but they were a little concerned that, oh man, this could be another settlement again. We're in England fighting this, because all of these suits have been in England, and none of them have been able to be successfully removed to California, where I'm sure Apple Computers would prefer. So they were a little concerned that it wouldn't come out in their favor again, or that Apple Corps might somehow be successful in getting a large share of Apple Computers. So again, a settlement was reached. This time, $500 million from Apple Computer to Apple Corps. And they effectively bought all of the trademarks and licensed back Apple Corps to the Beatles company so that they continue the use that they had been in. They're not going to grow it in any sort of way, but they can continue to police the copyrights that the company has and use it on any new product that's been coming out. So they both still exist, but it's been an incredibly expensive endeavor. And that's the question where I asked earlier, like, I don't know what Apple's doing. I don't know what Steve Jobs was thinking when he started this. Like, he could have come up with almost any other name. He certainly knew that Apple Corps existed and kind of chose to go down that territory anyways. But yeah. The last case study is something that I worked on myself. I've changed all the names to protect the innocent, and you won't know exactly what I'm talking about here, but it's an interesting case for me because it demonstrates the strength of what common law can protect you from. So in this case, I had a client by the name of Sparkle 5, F-I-V-E, and they sold widgets. They were a local company just based here in Washington State, but they did have some internet sales that had landed them in they sold something to probably every state online. The second company, Sparkle 5, with a 5, was an international company that had never done business in the United States but was moving into this market, and for probably reasons that they regret now, had decided that Washington State would be the first place that they landed. And they didn't really do any searching, and any basic Googling would have revealed the fact that Sparkle 5, F-I-V-E, which is selling the same kind of line of product that Sparkle 5 already was existence. You could find them over a decade use of work of this name. So the interesting thing was that Sparkle 5, number 5, at some point they realized that they had a problem and they had to deal with this. But the end result was that they ended up making a substantial settlement payment to a very smaller company that otherwise would have been able to lock them out of Washington State, and that they had made that their business choice and their beachhead to start in Seattle, Washington. So sometimes facts align in a very strange way, and And this also illuminates that even if you think your name is the same or different, we're using a number and not a spelled out. It doesn't know. It's oddly the same, and so it would create that sort of likelihood of confusion. You need to protect your mark from infringement. In order to do this, you need to show that you have a valid and legally protectable mark, that you own the mark as the plaintiff, and that if the defendant uses the mark to identify goods or services, it's going to cause a likelihood of confusion. I have a question over here.
What happens if someone's using a mark like in the marketplace, but the person who owns the mark is not defending it, but it's leading to confusion amongst people who are using these products?
Yeah, no, that's a great question, because if you don't defend your mark at a certain point, it just be considered sort of like there's a legal concept called latches, which means like you've failed to defend this mark. Starbucks, you let Farbucks exist for like another 5 years without you doing anything about it. You're going to lose your protection of your own mark because you weren't defending it in any sort of way. So a point that I was going to hit on a little bit later in the slide is like sometimes it seems like kind of nasty when a big company is coming after a small player. It seems like kind of like overpowering, but they're really just doing what they have to do because you can't allow usage to slip. Once you allow other people to use that mark, then you're going to lose your own ability to protect it.
But what if they're not actually interested in defending the mark, but you kind of can, like, if the users of the products are actually confused by it, but the person who owns the mark actually isn't interested in defending it?
Well, I think at a certain point, I mean, like I said, it's just going to lapse through latches, and then anybody else, I mean, it's probably going to create some confusion for a while. But at a certain point, it's just going to lapse, and then it's going to be kind of a free-for-all, and the second company using it is going to be, free and clear at a certain point, I don't come across too many people that are not interested in defending their marks. If they're not interested in defending their marks, it's usually because they're like, we're going out of business or we're failing or whatever, and in which case they would just probably abandon their mark anyways.
So I guess a related question is like intent to use, or what is the level of use required once you have a trademark, if that's clear. Because I'm thinking about a startup that I'm working with, or that has a company name, but its DBA is something else. Mm-hmm. So the consumer won't probably likely see the name of the company, the name.
They're just going to see the DBA. Yeah.
Right, but do you still protect the company name, and how critical, if the consumer is not seeing it, does that demonstrate use, I guess?
It does, because you're still sort of transacting in other sorts of ways, right? But realistically, you may decide like, well, I really would rather have the trademark protection on my DBA or my product line that the consumers do use. It can kind of go either way, but the holding company, or if that's what we're talking about, it still exists and it's still in commerce, and so it still transacts, it contracts with people, or it does things.
So if somebody else wants to use that name, as long as if you've had ownership before it or using it before, you can simply file for trademark protection, even if it's...
I mean, it can't be like this secret company that nobody ever hears of. I guess to your point, I mean, it has to be something that people would kind of recognize or would be able to find or search, and say like there's some product or goods associated with it.
Okay.
If I'm understanding the question correctly.
Oh, that's good. Okay, very good. Thank you.
Yeah. So there's a couple of different ways that you can kind of come across protecting your mark, and you could be sort of like the rigid policeman of the mark, and you can send out cease and desists that maybe have one particular kind of tone. Or there's been kind of a trend recently where larger companies are sending out almost kind of humorous letters. I don't necessarily recommend this, as your your go-to strategy, but it can work for your brand in a particular way, so it doesn't appear that you are beating up on a smaller entity. You can't really read the letter that comes from Netflix, but I'll read it because it is just kind of funny. It's the idea of like lawyers taking a more tone that's more in line with the brand that they're representing. And so they write, "Dear Danny and Doug, my walkie-talkie's busted and I had to write this note instead. I heard you launched a Stranger Things pop-up at your Logan Square location. Look, I don't want you to think I'm a total wasteoid, and I love you guys, and I love that you love the show. Just wait till you see season 2. But unless I'm living in the Upside Down, I don't think we did a deal with you for this pop-up. You've obviously creative types, so I'm sure that you can appreciate that it's important for us to have a say in how our fans encounter the worlds we build." And I guess I should have mentioned that these particular folks had started a pop-up bar called The Upside Down. And so clearly they love Stranger Things, but Netflix does have to protect the brand that they have built. So kind of a funny example. Again, as an attorney, sometimes I will take a lighter touch, sometimes I'll take a heavier touch. It's really case by case and it's situationally dependent. But I do think it's valuable for some of these larger companies that have such fanship of their own. I think it's interesting that they take this approach to trademark infringement because it's very effective. And it actually makes both parties look better. It doesn't embarrass the target, and it makes the larger company seem kind of reasonable, even though they're doing the policing that they need to do. What happens if you don't protect your mark? Or what happens when a brand name is so commonplace that it isn't even associated with the original product anymore? And that's what's called genericide. And so all of these former brands on here, they actually started off as something that was trademark protected and owned by a company, but they just became so popular that it was impossible to protect them anymore. So the escalator used to be owned by the Otis Elevator Company. Laundromats were owned by, or the name laundromat was owned by Westinghouse in the 1940s, and it was just meant to be an individual automatic laundry machine, and then it became synonymous with like places you go to wash your clothes. It's funny, the App Store lost its protection just within 1 year. So kind of in the olden days, it might take decades for something to fall into generic use. And the App Store, which was Apple would argue that they meant Apple Store. But with the internet and just broad, universal, instantaneous use of language, it can make things go generically very quickly. So you do have to be pretty on it. It could certainly, it could be upsetting if you're the makers of hacky sack and all of a sudden that got so popular that anybody can now make a leather bag with beans and call it a hacky sack, and all of a sudden like, oh, we've lost our marketplace advantage there. Those are actually an interesting thing is that aspirin was trademarked by Bayer. And they also had a trademark on the name heroin, which they lost control of that one as well. And here's some brands that are kind of on the bubble in terms of like protecting their mark. And so they will strenuously insist that you refer to them by their, if you refer to the product by the generic name. So if you're just talking about AstroTurf, like please, it's artificial turf, it's not AstroTurf. Band-Aid, Crock-Pot, same thing. Velcro is actually funny. They've got a very funny video online. You can find it on YouTube, where it's their lawyers singing about like, you need to use the term hook and loop and don't just call everything Velcro, because we're Velcro and we have an actual product called Velcro. Just don't call it that. It's hook and loop. Quick question on the, I think I've got like 2 minutes here and I'll go really quickly. And should you do it yourself or should you use an attorney? And I will say that, it's not an impossible thing to do yourself, but there's so many things to look at and think about that I get a lot of clients that have been just like, hey, I thought I could do it myself, and now we have this office action, and it's more expensive at that point for an attorney to go back and kind of fix what was done incorrectly than it is to just hire an attorney and do it right the first time. So You guys can read some of the things that might come up here. These are mistakes that I've seen just time and time again. And so I do recommend using an attorney for something like this. And not only because there's ongoing support that can come with having an attorney. Guidance on this office actions, answering questions along the way, having a paralegal track your applications and file for your renewals, and just keeping you informed. And we talked about global protection before, but I will just say one thing, that there's not a one-step solution to having your mark go international, but as long as other countries are part of what's called the Madrid Protocol, it will give you a one-stop kind of place to indicate, hey, this can go into this country, this can go into this country, and this can go into this country. You can file there on the World Intellectual Property Organization website, but it's going to be a country-by-country maneuver, but as long as countries are part of the Madrid Protocol, it's an easier solution. There's about 130 countries that have signed on to that protocol. And this is my last slide, but I just wanted to demonstrate just the difference in the various types of intellectual property that you might have come across before. Oh, it went fast. So, all right, that is the presentation, and I'm glad that we did Q&A along the way because I think there's no time for that now.
All right, thank you all so much for joining us today. And from all of us here at CoMotion Labs, a big thank you to Katrina. And we are about to go on hiatus for the summer quarter. Our next fundamentals installment will be October 4th. Mark your calendars. And have a great summer. We'll see you in the fall.